and alternatives to conservatorships. I just realized the recording started. So that is what we will be talking about today, going over conservatorships and its alternatives. So if we can go to the next slide, please. Okay, great. So we just want to give a quick disclaimer that this presentation is meant for educational purposes only, and it does not constitute legal advice or legal counsel. And that is because your situation may be unique and require careful and individualized attention. We give basically general information, just kind of the basics, the 101. So it's not really a one size fits all. And also keep in mind that we do try our best to be up to date with the laws and policies. However, laws are constantly evolving and changing in this country and in this state. So what may be relevant and current right now may not be the case with this presentation 6 months from now. So we just want you to keep that in mind. All right, so alternatives to conservatorship. So we're going to just talk quickly about the landscape of conservatorships, and then Daniel in the second half will be talking about alternatives. So generally before the age of 18, there are certain individuals that have the right to make decisions for people that are under the age of 18. And this includes decisions about health, food, clothing, housing, finances, education, and other personal needs. And when we think of the individuals that have that right to make those decisions, we think of parents for kids who are under the age of 18. Also guardianship. In California, this is for children under the age of 18. A court can order someone in California other than a parent to have custody of a child to manage the child's property or both. And there are also certain caregivers, and you can find that under the Family Code section 6550. And this form can be used by someone other than the parent to enroll a child in a school or to get the child medical or dental care. However, this does not give the person custody rights. And that link there includes that form, and it's an affidavit, and this affidavit should be notarized. So under that authorization, there's usually kind of two categories: school enrollment, and then the other category is medical and dental care. And for school enrollment, the requirements for the caregiver is that they should be over the age of 18 and take care of the child living in their home. With medical and dental care, it also includes those two requirements. The caregiver should be over 18, take care of the child living in their home, and also be a qualified relative. So these are generally the rights that people have, parents, guardianship, and caregivers for those under the age of 18. Now, what happens when the young person turns 18? If we can go to the next slide, please. Great. So when the young person turns 18, that young person now has the right to make decisions in their lives. They have that autonomy, they have that independence. And the issues of the person include basically everything: health, food, clothing, where they live, education, other personal needs, as well as their finances. So they have complete autonomy. They are treated like an adult. Can we go to the next slide, please? Great. However, there are certain cases and individuals where even when they get to age 18, that might not be the case for them. And this is where I'm going to talk about general conservatorship and limited conservatorship. And I'll just be describing what it is as a concept. And so general or probate conservatorship includes the following elements on the PowerPoint. It is a judicial process. And what the judicial process contains, it contains forms that must be filled out. The forms must be filled out with the court, and the forms must be served to certain people. For example, parents, grandparents, siblings, etc. And there's usually a hearing in this judicial process where the judge will make a decision as to whether the general conservatorship is warranted. And it really does take away the rights of the person that will be under the conservatorship. So for example, it may take away rights involving health. where they choose to go to school, whether they want to obtain a higher education, their personal needs, their finances, etc., their living situation, who they get to live with, how they get to live. It really does take away their rights. And it is for people who are ages 18 or older, because as we just mentioned, when you are younger than 18, usually the person that's making the decision for you is your parent or a caregiver. And it generally lasts until the court ends it or the consumer dies. So if a situation comes up where you want to contest the conservatorship and the court does align with you, the court has the power to end that conservatorship. Otherwise, it usually lasts until the entirety of the consumer's life. Next slide, please. Great. So that's general conservatorship, and that can be for almost anyone that is over the age of 18, and it's very much a case-by-case basis. With limited conservatorship, this is when a court judge appoints a person, a conservator, to assist an adult with developmental disabilities. So the person with the developmental disability will be the conservatee, and it's with someone that has a developmental disability that cannot provide for their own personal or financial needs. And just to clarify, an adult with a developmental disability is a person who has a severe and chronic disability because of a mental and or physical impairment. So I think we can all think of examples, autism, cerebral palsy, epilepsy, and intellectual disability. Those are all examples of an adult with a developmental disability, but that list is not exhaustive. There's a bunch. So limited conservatorships are generally targeted toward those individuals. And the judge may take away some or all of the following rights of the person with the developmental disability. So the right to determine their place of residence, the right to view confidential records, the right to marry, the right to sign contracts, the right to consent to medical treatment, the right to control their social and sexual contacts, and the right to make decisions related to education. So we can kind of really group all these elements here of the following rights into two categories. So limited conservatorship of the person themselves, or limited conservatorship of the estate. So limited conservatorship of the person, that's kind of what we see majorly on that slide. So the conservator will care for the person, protect the person, and provide the needs associated with daily life, which might, impact where they live, so their place of residence or their social and sexual contacts. There's also limited conservatorship of the estate. And limited conservatorship of the estate is where the conservator handles the person's financial matters, such as like paying bills and collecting income. However, this does not apply if a person receives public assistance, such as SSI. And this may be needed generally when there's an inheritance or lawsuit settlement involved for limited conservatorship of the estate. So the ones that you see on the PowerPoint right now are generally limited conservatorship of the person, whereas limited conservatorship of the estate is usually involved regarding financial matters and when there's an inheritance and or lawsuit settlement involved. Great. Next slide. However, because this is a limited conservatorship and not a general probate conservatorship, there are limitations on what the conservator can do. So remember, this is really for the benefit of the person with the developmental disability. So the conservator cannot do any of the following. The conservator cannot control the salary that a person earns in their work. They cannot improve harmful medical treatments. Because remember, this conservatorship is supposed to be for the benefit for the person with the developmental disability, that but for the developmental disability, they would not need this conservatorship. The conservator can also, is not allowed for the person to carry out drug treatments, to force the consumer to sterilize so as not to have children. The US has a long history of sterilization for people with disabilities, so this is absolutely not allowed. The conservator also cannot place the person in a facility or institution. They cannot accept that they give electroshock therapy to the person. They cannot accept that they provide psychotherapy to the person. And they also have other powers that have not been specifically authorized by the court. So with a limited conservatorship, everything is detailed as to what is allowed for them to do. So it's exhaustive. It's not just suggestive that, oh, you can take care of their social and sexual contacts, their education, etc. Everything that's listed there, that is the only things that they are allowed to do. So they cannot have other power that has not been specifically authorized by the court. All right, next slide. All right, so who gives information to the judge? We're obviously always worried about ensuring that all the facts are laid out, that there is a just determination of whether a limited conservatorship is sound and appropriate for the person with a developmental disability. So it's really critical that the information that's given to the judge is accurate. And this involves the court being involved. So the court investigator will first call the house, a residential place where the proposed conservatee lives, to set up a home visit. And after that home visit, the investigator will write up a report to the court to make recommendations about the limited conservatorship. And so the investigator will work with the person to explain the request and analyze it, interview the person and inform them of what the conservatorship process looks like. And the investigator will also determine whether the person is in a position to attend the hearing, whether the person opposes the conservatorship, and whether the person opposed the proposed conservator or prefers someone else. So that's generally the kind of information that will be provided to the judge. And now with regards to the regional center. So because the regional center provides services to those who have developmental disabilities, it's possible the regional center has already done this, but if the regional center has not already done this before age 18, the local regional center in your area will do a test on the proposed conservatee to determine if the person has a developmental disability. And if the person authorizes it, the regional center will evaluate and file the report with the court. And the report will include the following: the nature and degree of the consumer's disability, the type of assistance they need, the person's physical condition, the person's mental condition and social well-being, and recommendations on the rights requested in the petition. Next slide. So with limited conservatorships, it really involves all the main players that care for the person's rights. So that's why the regional center is involved. That's why, most importantly, the court is involved, but it also involves the Office of Clients' Rights, OCRA. And so OCRA provides assistance to regional center clients. OCRA is almost kind of like a sister to Disability Rights California, and they can help with a bunch of things, not just with limited conservatorships, but really anything related to the regional center and the client. So they may be able to help inform the person of their rights, as well as inform a person about the alternatives to conservatorship, as well as talk to the attorney or probate court investigator or help the person talk to them. And we also provided their number, their contact information on this slide. You will also be receiving all the materials afterwards. But if you just have any questions, not even about limited conservatorship, but if your child over the age of 18 is a regional center client, or even under the age of 18 not related to conservatorships, if you have any questions or matters, you can also reach out to them. Next slide. Okay, so what is the goal of all this? What is the point of conservatorships and alternatives to conservatorship? So the ultimate goal is to keep a person as independent as possible. A person with a disability is first and foremost a person, and we want to make sure that a person keeps their right to make decisions for themselves. We want to make sure that they have autonomy and that they are treated as a person, just as equal as anyone else, because conservatorships may be an avenue for oversight or abuse. And so we don't necessarily want that. We're not saying that for all conservatorships, but it does happen. I think, we've seen it in the news, like with Britney Spears, for example. That's just one example with a general conservatorship. So we spoke about general conservatorships and limited conservatorships. So now we are going to talk about a very important California law that was passed AB 1663. If we go on to the next slide, please. Great. So it was passed in January 1st, 2023. And what does Assembly Bill 1663 do? This new law essentially helps people keep choice and control over their lives as it relates to conservatorships. And so this law particularly helps people with disabilities and older adults get support from people that they trust, so that they are not forced into unnecessary conservatorships. So it really establishes supported decision-making as an alternative to conservatorship through this statute. And Daniel, in the next few slides, will speak to what is supported decision-making in detail. And so this also requires courts to provide this information and develop programs regarding this and other alternatives. So the law really makes changes to probate conservatorships in California to ensure that people under conservatorships have a voice. A person's desires must be respected, and that includes their preferences of who they want support from and use of alternative methods of communication. And so a court must consider if there are less restrictive alternatives to conservatorship. And this law will also make it easier for people to get out of conservatorships when the conservatorship is no longer necessary. It can be very much true that at a certain point in a person's life, they will need a conservatorship. But because of the conservatorship, perhaps in those 5 years, after 5 years, they no longer need that conservatorship. It might be, if they have a developmental disability, it might be, kind of taken down to a limited conservatorship, or it just kind of taken out completely. So it's really good that this law has been passed because conservators must be provided information, in language that they understand, not in legalese language, and the court must begin the process of terminating a conservatorship if the conservatee requests it. And if a conservator and the conservatee both agree to terminate the conservatorship, there is really no need for a hearing. So a hearing will only be held if the conservatee requests it and the conservator has a disagreement with it. That's when a hearing will be warranted. But yeah, so you can learn more about this assembly bill on the link there. It has definitely been quite groundbreaking in the area of conservatorships in California. And so these are the 6 alternatives that we are now going to go through that are generally alternatives to general and limited conservatorships. So we have supported decision-making, durable power of attorney, the advanced healthcare directive, the right to make medical decisions, the right to make educational decisions, and the right to administer finances. And I'm now going to hand it over to Daniel, who will be going over these really important alternatives.
Awesome. Thank you so much, Nadia. Thank you, Raymond. So like Nadia stated, right, she went over AB Assembly Bill 1663. So a product of this bill, of this law, is that now the state of California recognizes supported decision-making as an alternative to a conservatorship, whether a general probate conservatorship or even a limited conservatorship. So now people with disabilities have the right to retain capacity to make decisions by choosing people that are close to them, right, to help them make, understand, and communicate those decisions. And that's the objective of supported decision-making. And so through this, right, the person with the disability makes the final decisions about their own life. But of course, they do get help from their circle of support, the people around them. And then an individual who is in a supported decision-making arrangement, right, that person can change the people that are part of that supported decision-making group called supporters. So at any point, right, they can change supporters. If they no longer wish to have the support of somebody, they can simply express that and they will no longer be part of that supported decision-making group. So amongst many more attributes, right, some other characteristics of supported decision-making for people with disabilities is that it helps them achieve goals in life. It helps them make decisions about where, in what way, and with whom they will live. It helps them make decisions about where they want to work. And it helps them understand things that come up in their lives. Next slide, please. Okay, so for a supported decision-making, there doesn't need to be an agreement an agreement is not necessary, but it may be best practice to use a supported decision-making agreement, right? Because it serves as evidence and it demonstrates that a person is participating in supported decision-making. So like one example, right, that we can provide is under supported decision-making, a person, right, can attend a medical appointment, right, to see a doctor. And with that supported decision-making agreement, right, that gives them authority to help that person who is receiving medical treatment or is at the medical appointment to help them make decisions, right, or to express exactly or interpret exactly what the person that's being supported wants and needs. And here we have examples of what a supported decision-making agreement looks like. We have two. We have one from the ACLU, the American Civil Liberties Union, and then we also have one from Disability Voices United, which is a great organization that actually helped spearhead the supported decision-making law in California. And that particular example is in it's Appendix A in that publication that we just dropped in the chat, the link in the chat. Next slide. Okay. So now one alternative, right, to a conservatorship is the power of attorney. Some of you are probably familiar with power of attorneys, and we're just going to go into a bit detail regarding powers of attorney. So a power of attorney is a legal document, right, where the person with the disability, the consumer, gives a person that they trust the legal right to make decisions for them. So the consumer can give someone power of attorney to make decisions regarding their finances, their property, and even their education. Something that we do want to note here that is not on this slide, but it's important to note that a person must have the capacity to enter into a contract or a legal agreement in order to create a power of attorney. And one example, right? Children, anybody that's under 18 is not recognized to have the capacity to enter into a contract or a legal agreement. And for that reason, right, one cannot have a power of attorney over children. But that's one requisite, right? There needs to be a capacity to enter into a contract or a legal agreement in order to create a power of attorney. So the power of attorney can be general or limited. A general power of attorney is a power of attorney that only remains in effect while the principal or the subject of the power of attorney is alive. Also, if the principal becomes incapacitated, a general power of attorney will no longer be effective, right? So let's talk about what does incapacity entail, right? So some examples of how someone could become incapacitated, right, can include if they can't understand or communicate with others, their wants, needs, their desires, if they no longer recognize people or things that they were once familiar with, if they are experiencing delusions or hallucinations, if they don't understand the consequences of their actions, right? All these things can indicate that that person is incapacitated or does not have the capacity, right, required in order to enter into a power of attorney. So a limited power of attorney, on the other hand, right, only provides a very specific authority to a person or an individual. For example, a person can have a limited power of attorney to only help someone sell their home, right? But that's the only authority they're given. They can't make any other decisions related to anything else, only to selling a person's home. So that's a limited power of attorney. So we also have a power of attorney can also be durable or springing. And I'm going to explain what that means. So a durable power of attorney is one that lasts and is effective even when the principal, the subject of the power of attorney, becomes incapacitated, right? We mentioned that a general power of attorney ends when somebody is incapacitated or if they die, right? But a durable power of attorney will continue to be effective even if a person becomes incapacitated. So that's a durable power of attorney. Now, a springing power of attorney, this is a power of attorney that takes effect when certain conditions are met. Whereas the other powers of attorney take effect immediately, this one does not. And an example of when a springing power of attorney can take effect is in the event that a person becomes incapacitated or disabled, right? So the power of attorney will state, this person will not be given authority to do A, B, or C until only if I become incapacitated or disabled. So that would be a springing power of attorney. Next slide, please. Thank you. Okay, so now we'll talk about, in California, power of attorney for healthcare. And a power of attorney for healthcare is also known as a medical power of attorney, right? We have general durable power of attorney, and we also have a medical power of attorney. And this includes or gives somebody the ability to make decisions related to personal care of the principal, including but not limited to determining where their principal will live, providing meals, hiring household employees, providing transportation, handling mail, and arranging recreation and entertainment. But of course, this is in the context of a medical situation, right? And in order to get more details about this, you can refer to California law, also known as Probate Code, Section 4671. And something that we do want to note is that this power of attorney, this specific power of attorney, is included in a advanced healthcare directive, which we will go over next. And in order to learn more about that, you can refer to Probate Code Section 4701. Next slide. Okay. So the Advanced Healthcare Directive. So this is a form that gives another person the right to make medical decisions according to the person's wishes, and when that person is no longer able to make those decisions themselves. And there are two components to an advanced healthcare directive, right? The first component is that the person has to indicate their choice of who their healthcare agent is. In other words, a person that's going to be making the decisions for them. And the second component is that the person has to provide specific instructions about their healthcare. And an advanced healthcare directive usually goes into effect in the following situations, right? If somebody falls into a coma, if the person becomes mentally incapacitated or can't communicate, or a court finds that the person is incompetent and cannot make medical decisions because of that, due to a mental illness or dementia, for example. And here we have examples of what an advanced healthcare directive looks like. We have one. So something I should note is that most hospitals will have their own copy, but the form functions the same all across the state of California. It has the same elements, the same information. So for example, if this is something you're looking to pursue, right, you can visit your local doctor, right, or the hospital and ask them, I'm interested in an advanced healthcare directive. Can I be provided the form that the hospital has? So it's a very useful tool, and it functions a little bit like a springing power of attorney, right? But an advanced healthcare directive within it does have a medical power of attorney. Next slide. Okay. So those were alternatives, right? And now we're going to just categorize several ways that things can be done as an alternative to a conservatorship. So what are ways in which one can be provided the right to make other medical decisions, right? So we've already discussed the power of attorney for healthcare, or a medical power of attorney, or an advanced healthcare directive, right? And an advanced healthcare directive within it does have a medical power of attorney. So that's one way to provide someone the right to make a medical decision. But let's say that you don't necessarily want to make a medical decision for someone, right? But you simply want to obtain medical information or records of that person. And sometimes an example of this is, when somebody turns 18, they're considered adults. So a parent can't easily obtain those records, right, without having a written consent from an individual. So how exactly can you obtain that consent? So one would sign what's called a HIPAA medical information release form. So HIPAA is HIPAA, is an acronym for Health Insurance Portability and Accountability Act. That's the name of the law. But within it, right, the HIPAA privacy law, this is a sub-law, I guess you can say, right, that specifically prohibits releasing confidential medical information to someone other than a patient. And a HIPAA medical information release form must be used in order to obtain medical information or records even. So that's one thing that can be used, right? If you simply want to obtain records from a loved one who's already 18. And also another way, although this is not always necessarily effective, but you can also, you and another person, right, can call an organization together, and that person can then provide verbal authorization or permission to be provided information over the phone. That's not always effective because sometimes they will say, well, no, we need a HIPAA release form. And in that case, right, that's when you would use the HIPAA. Next slide. Okay. So the right to make medical decisions. So one way, right, make medical decisions for a loved one. And let's speak in the context of somebody who's already turned 18. So let's set a foundation. So we have a son or a daughter, right, who's 17, who's going to turn 18, right? They're receiving special education services through their school. But once they turn 18, right, they're considered adults. So at that point, right, they're, like Nadia stated, right, they're supposed to make decisions for themselves, or they're deemed capable of making decisions for themselves. So a school may not, right, allow you as a parent to participate in an IEP. Well, there's a way that you can obtain the right to make medical educational decisions for your loved one, right, who's transitioning, who's turned 18. And you can sign a letter under California law, under California Education Code, section 560.41.5. And this letter can be used, like I said, by someone who's already turned 18 and is not incompetent, right? They have the capacity to form a contract, and this will allow them to authorize their parent, right, to help them make educational decisions. And of course, some of you already know in California, students can generally be eligible for special education services up to 21 years of age, right? So this letter can be used for that purpose, right? To participate in making educational decisions when it comes to your loved one who's transitioning. And here we have a link that we'll drop in the chat, and it's a sample of what, or a template rather, of what such a letter would look like. A letter under California Education Code section 560.41.5. So that's one way, right? Another way, right, is you can also obtain a power of attorney. And that's another way. Here we have listed a limited conservatorship. That's another way. Of course, it's a more restrictive means, right? Because you virtually are taking rights away from the conservatee, but that's another way, right, where you can be given the right to make an educational decision. Next slide. So we have already discussed the process of obtaining medical information or medical records of someone else. So when a person other than the consumer, the client, the student, the beneficiary wants non-medical information from an organization, another form can be used, and it's simply a general release form. It's not as strict as a HIPAA release form, right? It doesn't have verbiage, the legal verbiage of HIPAA, but it will provide somebody authority in order to request information or to request records on behalf of a loved one who is a person with a disability, right? And let's say they're already 18. And the consumer or the person with a disability can sign the consent form to allow the release of information or records to someone else, a third party. And another way, right, is kind of similar, right? When you obtain medical information. In some cases it works or doesn't, but for the most part, when you're trying to obtain non-medical information, it's satisfactory to call an organization, an agency with the person. And as long as that person provides verbal authorization, right, for that person to, or permission for that person to speak with the agency or the organization, then they should be able to freely exchange information that way. Next slide. Okay. So to manage finances, right? Not necessarily the ability or the right to make financial decisions for someone, but to help somebody manage their finances. You can use a power of attorney or a representative payee, right? You can be appointed a representative payee, specifically for Social Security matters. You can choose someone or an organization to be a representative payee. for Social Security benefits, right, including SSI, SSDI, etc. Also, something else that can be done, right? You can have services written into your IPP if you're a regional center consumer to help the consumer with managing their money. For example, money management services can be provided by an independent living services worker, and that can be included in an IPP and should be discussed in an IPP meeting, right? If that's something that the family, right, or the person with the disability wants to pursue. Another tool that can be used, right, to help someone manage their finances is a special needs trust. So a special needs trust can be established, right, to help the person with the disability manage their funds. In that case, a trustee would be taking care of managing that person's money, right? The beneficiary, right, not the trustee would, the trustee can make every decision when it comes to your finances in the context of that special needs trust. So it's a little bit more restrictive, but it's a tool that can be used as an alternative to a conservatorship, right, where the person is stripped of that right. You can also have a joint bank account. A joint bank account can also be open with someone, right, that you trust to help the person with the disability or your loved one write checks, make deposits, or withdraw money. However, I do want to point out this is not ideal in some situations. For example, where you have programs where commingling money in a bank account could cause issues, this would not be the way to go, right? And one example that comes to mind is if somebody is receiving SSI benefits, right? If you have a joint bank account, that could affect eligibility for SSI because, of course, there's a resource implication. So, so yeah, just be very conscious of that if you're planning to open a joint bank account. Also, something related to SSI, right? Something that can be opened is a CalAble account or an ABLE account, as it's known federally. So CalAble stands for California Achieving a Better Life Experience. So under a CalAble program, the CalAble program, a person can save for disability-related expenses by putting money in an account, right, or tax advantage investment. So the only thing is that please be aware that if there is money in the account when the person with the disability passes away, then the money, in some instances, for example, if the person is older than 55 years old, can be recovered for this by the state if Medi-Cal was used to pay for certain expenses, medical expenses. So yes, so that's another way. We can go to the next slide. Okay, so now let's talk about the regional center. So there is information we want to point out. So under California law or Welfare and Institutions Code section 4655, a regional center may authorize some medical, surgical, or dental treatments in certain situations, namely in emergency situations. So if the consumer doesn't have an authorized person to give medical, dental, or surgical consent, or the person with the authority doesn't respond in time or within a reasonable time to the regional center director's survey to give or to not give consent, then the decision ultimately can be made by the director without that official consent. And in urgent situations, right, the director can also initiate the process of a conservatorship. And here we have a link to the law, right, the law for that authority that's given to the regional center. Something that we do want to point out, though, is that if there's a supported decision-making agreement, this would allow that process of medical consent to proceed more smoothly than not obtaining, but actually forcing consent, right, under Welfare and Institutions Code 4655. And this is because a person with a disability would have the support from others in helping them express their desires and wants. In other words, the people closest to the person with the disability, their circle of support, right, they're in a better position to understand what that person needs, right? They'll be able to interpret what the person needs or wants, whether through gestures, if they're nonverbal, for example, or through their own experiences with that person. Better somebody that has known the person with this disability for the majority of their life, right? Rather than let's say a service coordinator that sees them once a year, or the director who may have not even interacted with the individual. So that's something great about supported decision making here in California. We can go to the next slide, where we have a list of several resources, right, that you can refer to. And it's not limited to these. There's several resources out there. One of them is our publication from Disability Rights California that provides more information about limited conservatorships and the alternatives. And we also have another website called Support Without Courts. So all the agencies, all the organizations that helped pass the assembly bill, right, that created supported decision making, they created a website, and this is that website, Support Without Courts, and it has a bunch of examples of supported decision making agreements. There's also a supported decision making handbook that was created by Disability Voices United, which is one of those organizations that I previously mentioned, and it provides more. It was created before the law passed in California in regards to supported decision making, but the information is still reflects the way the law was actually passed. We also have the self-help resource for alternatives to conservatorship through California courts. So one thing about the new supported decision making law is that now courts have to create programs in their self-help centers, right, that will help people through, if they want to pursue a supported decision-making agreement or a supported decision-making arrangement, it will provide more information and can help them do that. Also, we have a link here to determining competency, right, to sign a durable power of attorney, which we previously stated, right, in order to enter into a power of attorney, one has to be deemed competent, right, to enter into a legal agreement or a contract. And that's a great resource that you can refer to. We also have a resource for advanced healthcare directives through Prepare for Your Care. It's a great organization. And if some of you are from out of state, a lot of this information, right, is specific to California. But if you're out of state, it also lists templates for advanced healthcare directives in other states. And it's also provided in different languages as well, if English is not your first or primary language. So those are great resources. And I think we can now stop the recording. And I think it's time for us to take questions. I think we can wait until the